Hi everyone, welcome to today's LawWorks Legal Primer Series webinar on Wills, Estate Matters and LPA. This webinar is organized by Pro Bono SG in collaboration with NTUC. My name is Stephania and I'll be your moderator for today's webinar. So before we begin, there are some housekeeping matters that I would like everyone to take note of. Today we'll be using Pigeonhole Live for our Q&A session today. You can submit your questions at any point in time during the webinar and also vote for questions by others that you would like the panelists to answer. So if you have a smartphone or tablet with you, just launch your internet browser and enter www.pigeonhole.at into the address bar. Then key in our event passcode, which is LAWWORKS LawWorks02 as shown on the slide. Alternatively, you can click on the link shared in the chat function to launch Pigeonhole on your device. If you are viewing this webinar on your laptop or desktop, you should receive an invitation to launch Pigeonhole as well. Next, a copy of the slides will be provided to you via email tomorrow, so do look out for that email. And finally, please note that today's discussion is not intended to substitute any form of professional legal advice. If you require specific legal advice, please consult a lawyer. So with that, I would now like to welcome our distinguished speakers for today's webinar, Dr. Adeline Lam, Mr. Patrick Tay, and Mr. Josephus Tan. Allow me to first introduce Dr. Adeline Lam. Dr. Lam is a senior consultant in the Department of General Medicine and clinical co-lead ACP team at the Tock Seng Hospital. She's also a member of the Advanced Care Planning Steering Committee of Singapore. Next, joining us on the panel today is Mr. Patrick Tay. Mr. Tay is the Assistant Secretary General of NTUC and the Director of NTUC's Legal Services and Strategy Division. He's also a Member of Parliament representing Pioneer SMC since 2020. And finally, we have Mr. Josephus Tan. He's the Managing Director of Invictus Law Corporation and specializes in criminal defense work. He's deeply familiar in working with young persons and was recently appointed by the President of Singapore to serve as a panel advisor to the Youth Court. Josephus is heavily involved in pro bono work and has been conferred numerous awards for his work in this area. Panelists, thank you for joining us. Now, for today's session of the LawWorks Legal Primer series, we will discuss a topic that every adult person ought to consider, which is wills, estate matters, and LPA. Now, if you have signed up for this webinar, you have already taken that first step towards making some perhaps very difficult, but definitely necessary decisions in your life, and also for the benefit of your loved ones. Now, here's an overview of the topics that we will be discussing today. So Josephus will be sharing with us about wills as well as the lasting power of attorney, LPA, before Dr. Adeline goes on to share with us about advanced care planning and advanced medical directive. Patrick will also share with us some of his personal experiences that he has encountered regarding these issues. Now, let's start with our first topic for today, which is the will. And Josephus, maybe you can share with us a little bit more about why people need to make a will and who should make a will and why.
Well, I think maybe because of time limitation, I think we'll just keep to some very general concepts about wills. Okay, so I think long and short of it, I think the first thing that everybody should know is that, okay, will is important. Why? You have worked all your life, you have accumulated so many assets, so much assets, and probably at the end of the day, you might just want these assets to go to people that you want them to receive, your beneficiaries, so-called to speak, right? Because if you passed away without a will, then of course, in legal speak, we will say that you die intestate. So that means the Intestate Succession Act, this law will apply. So it governs the distribution of a deceased estate should the person passed away without a will. So meaning to say, long and short of it, the respective authority will do the distribution for you according to your blood ties at different tiers. That's really the long and short of it. So a will kicks in when you passed away. All right. So I mean, common questions will be like, is if I do one will, is that the one and the last will that I'll ever have? Answer is no. We have seen so many people, they just update their wills, year on year, or every few years, because I think we can all agree circumstances change, whether is it personal, financial, professional, or otherwise. So you will just keep updating your wills, keep amending your wills. But the latest one, okay, before you passed away, right, that stands as the latest one. All right. So every new will supersede the previous one. That's really how the law works. So and also, I think there's a difference. Just really, this is something to take note of. If you have written a will when you're single, the current law states that if you get married, the law when you drafted as a single will be invalidated, automatic, invalidated, and that's by law. So that means upon marriage, you have to redo a will lah. But don't ask me why. Okay, it's a bit strange. But what if you are separated or you're divorced, right? Does that mean the same? Answer is no. So if you are going through a divorce or you're already divorced, right, the will that you did previously during your marriage stays intact. All right. So usually we advise people, then you should maybe update your will, because if not, right, the will that you did during your marriage will still be valid upon your divorce. All right. So these are just some of the concepts that we want to throw out there during this webinar, for people to have a better understanding. And before we move on to the next question, I thought I will also want to let audience understand this. Very common question. A lot of people ask, hey, do I really need a lawyer to draft a will? Answer is no. Okay, you can draft the will yourself. Okay, you can get a financial planner to do it. All right, or anybody who's trained to do it. It doesn't have to be a lawyer. The law doesn't state that, a lawyer must be the one drafting a will. Okay, but you see, therein lies the problem, because under the law, there are certain provisions that govern the validity of a will, a legally valid will. So things like, for example, you need to have an executor, and at least one beneficiary. You need to have 2 independent witnesses, So certain clauses must be stated in a will, falling short of which it might invalidate the will. So we always advise people it's better to get people who are trained in this, I mean, of course, lawyers, we are trained in this. And to that extent, you have that certainty that, these are practitioners, But of course, a non-legal person, a non-legally trained person, a non-lawyer, right, will be able to do that also if they receive the right training. All right. So really, I think the answer to that is that you don't need a lawyer to draft a will. You can do it yourself. I mean, yeah, just go and Google and just read out, what are some of these very important legal provisions which must be seen or must be stated in the valid will. Yeah.
Josephus, you just talked earlier about, you can change your will anytime, and you in some circumstances, you have to update it depending on what stage of life you're at. Is there a limit on the number of times that you can change your will? If you are a very fickle-minded person, can I just change it every other day?
Answer is yes. In fact, I will love it if you change it every other day, because if you come to me, that means I make money every day. Correct. So the thing is that the law doesn't say that you can only change 10 times, or it doesn't say that, oh, you can only do one will. No. As what I said earlier, you can keep changing it. All right. Keep updating it at different stages of your life, because some people, they do it when they're single. Then under the law, if you are married, then you have to do a brand new one. And the thing is that even after marriage, right, maybe a few years later, you start to plan for a family, you start to have children. Hey, then you update again. Right. So really hard to say. Or other circumstances will be like, oh, maybe you, like, for example, HDB upgraders, right? So yeah, maybe the first few formative years of your working life, you're staying in HDB. And after that, hey, you accumulated some wealth. You decided to upgrade to a condominium, a landed property, right? You start to have a lot of other investment portfolios, policies. And that's where you might also want to think about updating your will to include all these into your will as part of your assets. Yeah.
So we have a question also. Can we amend the will to existing wills by ourselves? I think Josephus also answered that. You can actually create a will yourself, and I think likewise you can amend the will yourself. Then the question is, what do I do with all the outdated wills or all the wills that I want to have superseded?
I can only answer I mean, to your preference law. Some people, they prefer to tear it. Some people, they prefer to burn it. Some people, I don't know, they decided to use it, fold into origami, aeroplane, or whatever, But the law is very clear, okay? The latest one with the latest date will be the one recognized in law. Okay, so for all those previous wills, really, I mean, if you ask me, even if you leave it lying around, in the eyes of the law, right, they will recognize the one with the latest date. That is really what it is. But we will advise our clients, I think, a prudent thing to do will be to destroy it, lah. Don't add to the confusion, because we have seen real life cases whereby there's this old lady, you know, when she passed on, right, she has like, I think 7 kids. And now the 7 kids are, I think 5 of them all had a copy of her previous will. Then we all came to find us, you know, we were like, wow, 5 different sets of wills done at different stage of her life. And then, but I think the answer is very clear. According to the law, the latest one will stand in the eyes of the law. Yeah.
So you mentioned just now that one of the requirements of a legally valid will is also to appoint an executor. So how should people go about choosing their executor? And one of the questions we have from the audience is, what if you don't have a family or next of kin to be an executor?
Very, very good question. Okay. First and foremost, this is especially, okay, so in law, I mean, just to be technical, the guy we call executor, the woman we call executrix. Okay, so far, I don't know of any non-binary term to describe executor or executrix. Okay, so for the guys, please, whoever you want to name as your executor, or in fact, for the ladies too, please name somebody that you know very well, that you trust, who can act in your best interest, okay? Who you expect you can trust to carry out your wishes upon your death. Because we have seen cases, you know, like people coming up to us and they just bring some random people that they just got to know at the food court or at the hawker center and say that, hey, I want this person to be my executor or executrix. We'll be like, huh? How do you know this person? They say, oh no, we every day drink coffee lah. I'm like, no, so try not to do that, okay? If you can, usually we see most people will appoint somebody from within the family, their children, especially if you do have. But to answer the second part of the question, if let's say really you have nobody, all right, there's another avenue. You can actually appoint a professional executor and trustee. So professional, like for example, some law firms, they provide such services, or even a licensed trust company. Yeah, there are companies out there who provide professional executorship as a service. But of course, I think you have to pay a premium for it.
Okay. And then I think we have a lot of questions streaming in from the audience. So let's just take the opportunity to answer some of them.
Okay.
I think we touched on this earlier as well. If I want to have a DIY will, what do I need to do to ensure that it's a valid will? How many witnesses do I need? And maybe just to add on to that, are there any requirements for witnesses?
Okay, first and foremost, I cannot tell you lah. I tell you that I spoil my own rice bowl, right? Okay, no lah, kidding. Okay, basic stuff, okay? Legal validity of a will, simple. I already said you need to at least have one executor or executrix for that matter and one beneficiary, all right? Inside, you also need to state a revocation clause to say that, hey, you know, previously, if you have done any previous will, those are invalidated lah. The current one stands lah. And then, of course, I think there will be a provision that states that, you know, everything under your name, both movable, immovable, rest and residual, everything lah, okay? You basically, after paying off the debts, if any, then that is where you want to pass it to this particular beneficiary. So if let's say it's just one, then it's 100% lah. So the numbers the apportionment must round off to 100%. So for example, if let's say you have like 4 children, right? You should ideally, like, if that is your intention, to give equally 25, 25, 25, 25, right? Or you can give like 50, you know, 30, I don't know, 10, 10. You can, but everything adds up to 100. Because the problem is that a lot of people, we have seen some cases whereby, I don't know whether is it a typo error or what, the numbers do not add up to 100. Then that means, let's say, for example, you only add up to 90, then the balance 10, right? Actually, in law, what that means is that it's a question mark, you know. That means, technically, if in short, it seems like you have only half a will, you know. It's like the other half, the so-called 10%, right, is unknown. So then what's the point, right? If you want to do a will, then do it properly, you know. And also, I think very crucially, as some of you guys are very aware of some of the recent incidents whereby, I think when you talk about witnesses, under the law, you need at least 2 witnesses. And these witnesses must be independent. So, meaning to say, for example, if you are the beneficiary of the will, then you cannot be a witness. Yeah, makes sense, it's conflict, right? And also, even if your spouse also cannot be a witness. Okay, so if you are a beneficiary, remember that. Okay, so usually if you go to a will writing company, a law firm that provide will services, usually all these outfits, right, they will provide their own witnesses lah. That means they are not a party, a vested party to the will itself. Yeah, these are some of the very basic legal parameters lah that you have to observe if you want to draft your own will lah. Yeah.
So I guess from the other perspective, if you are being asked by someone else to be a witness for that person's will, you also need to be careful and make sure that you fulfill the requirements to be a witness. And then on the other side of the will, we have the beneficiaries. So is it necessary to inform the beneficiaries that you guys are listed in my will? And what if there's a change in the beneficiaries?
Actually, this one, if you ask me, it's up to individual. We have seen some customers, they don't want to review because like especially the parents their children, they say, hey, if I tell my children, I give them all my assets, then I scared they end up lazy, they don't want to work, this new generation, very hard to understand, blah, 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 so it's really up to you. But if you ask me, I think what is a prudent advice is this: if you do a will, at the very least, inform your executor because we have seen some customers, actually quite a sizable pool of them. They do a will, they tell us, they say they want to keep it a secret. They were like, huh? Meaning what? They said, no, I want to keep it in the cupboard. I'm like, Auntie, that means if let's say you pass away, nobody knows that you put a will in the cupboard. That means technically you die without a will, nobody knows you got will, So at the very least, commonsensically, you got to at least tell the whoever is appointed as your executor about where you keep your will and they're appointed as one so that they know upon your passing, they have something to do. They need to do something for you. That's the whole point. Beneficiaries, if you ask me, I think totally optional. In fact, most of the time, based on the cases we have handled, people don't tell the beneficiaries because beneficiaries do not have to be a human. It can be a legal entity. It can be a corporate entity. For example, charities. Non-governmental organizations. So like, for example, we have seen people donating to SPCA. I think it's quite rare for people to give SPCA, to name SPCA in their will and then call SPCA and say, hey, by the way, I name you as a 10% beneficiary in my will. No, they don't do that. So want to give already. But executor must inform, it's prudent.
So what happens if we don't do that? We have a question here. So who informs the executor if the appointed executor is not a family member?
Wow. Very cheap question, if you ask me. I mean, okay granted that currently we have this thing called the Will Registry under the Singapore Academy of Law. So it's an index, it's a database. So for example, we will encourage our clients, if after you do the will already, you can actually register with this Will Registry. But it doesn't store your will, but it is just to register with the database so that, your next of kin, right, upon your passing, if they need to check whether you have a will or not, they can just go into the registry to check. When did you do your will? At what place did you do your will? So these are very, very brief registration information, so-called to speak. But really, it's a very difficult question to answer because if you are going to do a will, you're not going to tell anybody about it. Even your executor doesn't know about it. Then it doesn't make sense, right? Then what it's like hide and seek, nobody will know any better what to do with your assets, Yeah.
Okay. And then what happens to the will when the beneficiary passes away? For example, a beneficiary is meant to inherit certain assets that you have, but before that, the beneficiary has passed away before it can even take place.
Very common question. Also a very good question. Okay, but without confusing you, okay, actually we use Latin terms in law a lot. So there are two ways, but in general we call it pre-decease. So we always advise clients to put in a pre-decease provision, meaning to say that, let's say you have one son, one daughter, 50-50, right, 100%. So we will advise them to put in a pre-decease provision to say that in the event whether the son or the daughter passed away before you, right, then you got the question mark for the 50, that means it will go to the surviving beneficiary. So this is what we call a pre-decease. Actually, if we want to go more technical into it, pre-decease as an umbrella caption, there are two types. In Latin term, one is called per stirpes, another one is called per capita. The one I just described to you is called per capita. That means whoever is the survivor will take everything. But per stirpes, that one is only for your direct heirs, meaning to say your direct bloodline one must keep within the family. A bit different. Because we have also seen people who drafted per capita pre-decease, meaning to say, oh, I have one son, one daughter. If my daughter passed away, her share will go to the zoo. Or because she likes animals, she will go to SPCA. Then you cannot apply the direct heir pre-decease, so-called to speak. Correct? Yeah. So yeah, advisable. Please put a pre-decease, okay? Important.
Okay, I have a very interesting question here because it foresees, I mean, there are a lot of assumptions here, but what's the best way to ensure that essentially assets that you're leaving behind for your daughter doesn't fall into her husband's hands in the event that her daughter gets a divorce?
Wow. Firstly, very technical question, very personal question. This one must seek professional legal advice. But okay, the long and short of it is this. Usually we advise clients, die means die already. You don't know what's going to happen, right? Give means give already. But if really, I think if you have sizable assets, and when we say sizable, is in the millions, multi of millions, and we will advise clients like that, you know what? In fact, you should set up a trust. Yeah. So you should, long and short of it, a trust deed is where you actually can give very specific instructions as to how you want the assets to be managed or to be given in what form and what manner. Okay. And you can really stipulate all these weird provisions that you want, but that is really a trust deed. But if you ask me, I think by and large, most people, I think will just settle for really a very basic will, because like I said, to set up a trust deed is actually quite an expensive affair. Yeah. So I think that's really a very simple way to answer that question. But really, if you want more details, please seek professional legal advice, okay?
Okay, now maybe we can talk about what kind of assets should go into a will. And this is my question. Can we talk about things such as caregiving arrangements? For example, I have children, and can I specify in my will that, for example, I want my children to be taken care of so and so after I pass on?
Very, very good question. Can also be technical, but I'll make it very simple to understand. Recently, we see more and more of this. Okay, so in law, in short, we call it testamentary trust. So in your will, we have seen a lot of people doing this, not just for the children, but also for their elderly parents, which I think is a good thing. It shows a lot of filial piety, Singaporeans the mouth like to complain, but the heart very nice one. Okay, many of them, they want to provide for their parents, their children. So, for example, how the testamentary trust work, right? For this group of people, they will say, okay, in the event if I pass on, all right, I will give, for example, 500,000 to this only child of mine. And at the same time, from this 500,000 given to him, every month he will receive a stipend, allowance of $2,000. For his welfare, for his living expenses, blah, 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 until maybe when he turns 21. Okay. Or if, let's say, in the event, if let's say, for whatever reasons, the son doesn't live past this age, then of course you'll go back to the estate and then to be redistributed, something like that. So yes, to answer that question, right, you can set up a testamentary trust provision to provide for your parents, to provide for your siblings, to provide for your children. Yes, you can. It can be very, very specific in that sense.
Okay, and this is a very highly voted question. Is cash or property inherited taxable in Singapore? Basically,
my understanding is that there's no inheritance tax no estate duty tax That is my understanding. But for more information, please check out IRA's website, okay? Yeah, or speak to a tax lawyer. But long and short of it, answer is no.
Okay, and then what, I think I have two questions relating to the Intestate Succession Act. And one way to put it is, actually, if I already intend for my assets to be distributed equally to in accordance with the Intestate Succession Act, then do I actually still need a will?
What a weird question.
Or I mean the follow-up question is, actually, does doing a will speed up the process?
Okay, I'll give you a very simple example. So, 小康之家, right? Small little standard family in Singapore. Okay, husband, wife, and 2 children. Whether 2 boys, 2 girls, 1 boy, 1 girl. Okay, so family of 4. Okay. If you have a will, so usually what we see, you appoint your wife as an executor, and then after that to give to all 3 of them or give to your 2 children. Let's say 2 children. Okay, so basically 50-50 each. Okay. Standard with a will. But for example, if you die without a will, in this same example, under the Intestate Succession Act, what it means is this: after you apply for the letter of administration, long and short of it, a court order for those who died without a will, okay, the distribution will be this: 50% goes to the wife, 50% goes to the 2 children equally. You see? So it's actually fixed, it's tiered. For example, what if you have a wife but no children? Then it goes to the wife. But what if you have no wife and no children? You're single. Then they will trace your parents still alive. Then parents not alive. Or got uncle, auntie or not. So it's a tiered system related by blood. You see? So really, if you ask me, why do you need to do a will? Why is it important? Because you see, there are just two things. Having a will, right, save money and save time. Really, the long and short of it, even for LPA, is the same thing. We shall come to that later. Because if you passed away without a will, common sense, nobody knows your intentions, who you want to give, how much you have. So the process for applying a court order is a long one. And of course, we all know, like, if you get a law firm to do it, or even if you do it yourself, it's fairly complicated. If you get a law firm to do it, they need to spend a lot of time. They charge more money for it. All right. But if you have a will and you passed away, your intentions are set very clearly. And the process to getting a court order, what we call a grant of probate, is so much more straightforward. Usually between 2 to 3 months, you get a court order. And the cost is actually relatively affordable. I think right now in the market, the range can be anything from like $800-900 all the way to about $2,000. But if you die without a will and you have to apply for that court order called a letter of administration, easily you're looking at costs, legal costs, a few $1,000s. All right, can be $3,000-4,000 or even up to $6,000 or $7,000. And the time on average to obtain a court order if you die without a will, easily you're looking at 9 months, 12 months. The fastest you get it about 6 or 8 months, So you can see the difference. It's really down to time and money. So we always advise people, do your will, do your LPA. Why? Don't leave the burden to the people that you leave behind, because they are the one who is going to spend the time and the money to do all of this, if you are going to pass away without a will. Yeah.
Okay, we have still some questions on wills, but maybe we'll leave that to the end of the webinar if we still have time. Let's move on to the next topic, which is the LPA, lasting power of attorney. So Josephus, maybe share with us a little bit more about what this instrument is.
Okay. So long and short of it, will, it governs the assets, who you want to give, what you want to give, but it kicks in when you die. Yeah, when you die. LPA different. LPA, lasting power of attorney, it kicks in when you lost your mind, mental capacity. Okay? A lot of people, they very funny. They come to me, they say, hey, Josephus, I only want to do will. I don't want to do LPA. I say, why? No, because I know I will die, but I will not be siao. You know what I mean? I say, well, how can you guarantee this kind of thing? As we all know, like aging population, it's not just a Singapore problem, it's an Asia problem, So people are living longer. All right. But the thing is that we have seen a lot of problems are associated with the aging population, which is like, for example, dementia, Alzheimer, Parkinson's, It's like people start to lose their mental capacity. But so they are still living, but it's just that they can no longer function their day-to-day. Whether is it like their day-to-day living or doing like basic stuff like going to the banks, doing grocery and all that, or even bring themselves to see the doctor. All right. So this is where LPA is important. So just to recap, will governs your asset distribution upon your demise. LPA really governs your day-to-day. Who you want, who you want to appoint to take care of you and to help you to do largely two things, essentially your personal welfare and your property and finance. These are the two main powers, and the powers are great. Okay, but of course we will come into detail as we go along. Yeah.
Okay, and I think for LPAs, you also have to choose certain people to basically make decisions on your behalf when you lose mental capacity.
Yeah.
So how do you go about doing it? How many people do you have to choose? Are there any requirements for these people?
First and foremost, again, I say, don't choose people from the food court, okay? No people from kopitiam, okay? Very, very important. Men, women alike, okay? Especially for LPA, even more so if you ask me, it's like you should appoint people that you trust, okay? Who is going to look after your welfare. Very important, okay? The powers that you are going to grant to your donee, so in LPA, the person doing the LPA is called a donor. The people that you are going to give the powers to are called a donee. The powers you are going to give to a donee is very, very great. Okay? You need to trust them because you lost your mind already, right? So you really need to have trust that they will take care of you, And of course, we know there was a very big case, right, years ago, whereby, there was a case of elderly woman, very rich, befriended a tour guide, right? And then the tour guide became the appointed donee. And instead of taking care of her, right, when she has dementia, right, actually squandered her money, for his own purpose, wow, buy expensive paintings, buy a big house, go for a big holiday. You see what I mean? And then, of course, ultimately, we know what happens. He got taken to task, he got convicted and sentenced to jail. Okay? But really, I mean, if you ask me to avoid all these problems, right, is to really, really appoint somebody that you trust to take care of you when you lose your mental capacity. That is the safest bet.
So how many people can I appoint? Can I appoint my whole family to be donees?
Very good question. Okay. But so far, okay, Office of Public Guardian, or in short, we call it OPG under MSF. You can go online, you look at it. Okay, standard, there are two. LPA 1, LPA 2. Form 1, Form 2, we call it. Standard, most of the time, people will do Form 1. Form 2, customization. Okay. Expensive, at the same time, is customized to individual needs. Okay. So by and large, Form 1 is the one that you can really download from the OPG website, and that is where it's more straightforward. So take a few boxes, the powers you want to give and all that. And if you look at Form 1, standard form, donee 1, donee 2, replacement donee, standard. So the answer to your question is no, you cannot appoint your whole family. You cannot appoint like 20 donees, no lah. Okay, because like I said, the permutation is endless, but donee 1, donee 2, and replacement donee, maximum. Okay.
So what happens if donee 1 doesn't agree with donee 2? And there's a dispute as to how to manage the person's personal affairs. Okay.
A bit technical, this question, but if you look at the form, right, because the powers that you're going to give to your donees, right, donee 1, donee 2, for example, it also depends on what kind of powers. Like just now I mentioned earlier, on one hand, you have personal welfare. On the other hand, you have like property and finance. So it can also be jointly or severally. So really what this means is that it can be a case whereby you appoint donee 1 to in charge of personal welfare, donee 2 in charge of property and finance. It can be like that. Or it can be both of them decide on everything. So it really depends on how you want it to be. All right. So you are in the best position to know. That's the reason why I mentioned earlier, appoint people that you trust to take care of your welfare as a whole.
Then what happens if I don't have an LPA and I lose mental capacity?
Xiao liao. No pun intended, but xiao liao. You know why I say that, right? Because if you lost your mind, you don't have an LPA, okay lah. But in law, we still have a solution. There's this thing called deputyship. Okay. Again, just like wills, right? It's about time, about money. If you make an application for deputyship, it's costly. Again, like I said, it's in the high thousands. And also the time taken to apply for the deputyship is long. Okay, long and short of it, deputyship means that you try to speak to the relevant, usually next of kin, family members, right? And to appoint somebody to be the caregiver for this person. So that is really the basic understanding of deputyship. All right. So it's a complicated, it's a long drawn process, and then usually lawyers they charge quite a high fee for this. So that's the reason why we say, please, when you still have your mental bearing, quickly go and do your LPA. It's so simple, so straightforward, Spend a little bit of money and just get it done. And then after that, you can conquer the world. Yeah.
Okay, maybe now it's time to take one step back and let's consider this from a medical perspective. So Dr. Adeline, how do you actually determine if someone has lost mental capacity? And maybe just to add on a layer of complexity, how do you do this when someone's physical health is in rapid decline?
Thank you for that question, Stephania. And thank you for all your sharing, Josephus. It was really interesting and I learned a lot as well. So now my turn to share with you a little bit about mental capacity. So what is mental capacity? Why I keep talking about it? So mental capacity is actually the ability to make decisions and to understand the consequences of those decisions. So there are our Mental Capacity Act came about in 2008 and it came into effect in 2010. So there are 5 principles of mental capacity. The Mental Capacity Act actually helps to protect the rights of adults to make decisions for themselves. And it enables an individual to appoint a trusted person to make decisions on their behalf when they lose mental capacity. So this mechanism, as earlier mentioned, is the lasting power of attorney. So let me go through these 5 main principles with you. They are very simple. Once I go through it, I try to simplify as much as possible. The first 3 principles are about the person. So first, we must assume that everyone has capacity unless proven otherwise. So it doesn't matter how old or whether the person can hear or the person can see, everybody has the right to make a decision. And second, we must take all practical steps to help this person understand and make the decision. So that means that if you have a person who has a hearing impairment and only speaks dialect, so gong Hokkien wa, so we have to get them hearing aids and get a translator to speak to them in Hokkien. And that's the best way to actually optimize decision making, because then they will understand what is the decision and what is the consequences. And the third point is people are allowed to make unwise decisions. So what does that mean? You can give your 10 million to your dog. It's okay because it is your decision. All right. So no matter how unwise, I have a picture of Alan Robert there climbing up the 73 floors of this high tower. He's allowed to make decision. He may call it unwise, but he's still allowed to make that decision. So those are the first 3. The second, the 4th and 5th principles are actually what you do for the person. So the 4th one is, if let's say the person cannot make decision and you have to make the decision on their behalf, then the decision has to be in the best interest of the person. So whatever is best for this person, and the decision has to be the least restrictive. That means that if this person wants to go home, you cannot say, no, I want to make you go to a nursing home, which is very restrictive. You have to try and optimize the situation so that you can act in the best interest of this person. So that's the 5 main principles of Mental Capacity Act. And so when you have, you're the LPA, you're the donee, right? You have to remember the Mental Capacity Act and act in the best interest of the patient. Okay, next I will go through the mental capacity assessment. So why is this so important? Now, if you want your LPA and your will to not be contested by your family, then make sure that when you do your LPA and your will, the mental capacity is intact. So what does that mean? How do you assess that? How do we decide whether a person can make decisions or not? Firstly, actually, there's just 4 steps. And let me go through the 4 steps with you. So first, we have to make sure that the person who is trying to make the decision understand what is the decision that needs to be made, okay? Understand all the options and understand the consequences of the decision. So that's the first step. The second step is to make sure that they can retain the information. So that can get a bit tricky if the person has dementia or has some memory issues, but the retention of the information doesn't have to be for weeks and months. It just has to be long enough for the person to be able to understand it and then weigh the pros and cons of that decision. And once they have that decision made and it makes sense, then they need to be able to communicate that decision to you. Now, what happens if you find that after you go through these 4 steps, right, you find that, hey, the person does not have mental capacity. What are we to do then? So that's when we have to make a decision on behalf of the person. And when we make this decision, we usually take into account the best interest, as I mentioned, the least restrictive, and we have to take into account any previous advanced plans, any healthcare wishes that the person has made before. So advanced care planning, which I'll talk about in a while, is about communicating and documenting your healthcare wishes so that this can be used when you are no longer able to make decisions. I hope that answers your question.
Actually, Dr. Adeline, what you just said seems to be a very, very actually difficult exercise altogether, I think, for medical professionals, because would it be correct to say that loss of mental capacity also exists on a spectrum, meaning that if it's of a very severe stage or it has deteriorated to a very severe stage, then these 4 sort of parameters could be totally lost altogether. But it could also be a situation where you have some memory loss and certain reduced intellectual functions, but actually you are still able to make some decisions. It seems like a very tricky kind of assessment that needs to take into account so many factors.
Yes, you're absolutely right. It can become very, very tricky. And so sometimes we do get the psychiatrist to help us for those very gray cases where the dementia may not be very severe or the patient has some mental illness that is affecting decision making. Then we do get a psychiatrist to come and assess the patients. But otherwise, going through these 4 simple steps, we try to go through it using very simple language, trying to overcome any barrier that comes. So hearing and visual impairment sometimes can be a bit limiting. Sometimes you have to write it out for them and go through it slowly to help them understand the decisions that need to be made. And if they do have some issues along the way, see whether you can overcome these barriers. And if it really cannot be overcome, then perhaps they do not have the mental capacity. I think one thing to highlight is that you make a decision for each thing. So you cannot say, I have mental capacity to decide on where I live. I also have mental capacity to decide on my financial situation at the same time. We usually assess one thing at a time.
I see.
Yeah, hope that's clear.
Yes. So now we want to move on to something slightly different. We earlier discussed the will and the LPA. So Dr. Adeline, can you tell us a bit more about some of the other ways that people can plan for themselves in the future? And this relates to the third part, which we will talk about now, which is the advanced care planning.
Thank you, Stephania. So advanced care planning, that's my favorite topic. So what is that? Has anyone heard about that? Now, how many of you have gone for holiday? Have you been on a holiday recently, Josephus?
Yes.
And how long did it take for you to plan your holiday?
I don't know, few hours.
Oh, that's pretty good.
I went Bangkok, don't have to plan much. Yeah.
I see. So most people, unlike Josephus, will take quite a while to plan their holiday, right? Because you have this nice holiday at the end of the year or in the middle of the year. So we usually take a long time to plan and to decide where we want to go, who we want to go with, what we want to pack, what we want to eat when we get there, where we're going to visit. Are we going to go during the school holidays? We're going to go during like the winter season. So many questions, so many things to consider.
Sometimes you can go alone, right?
Yeah, can. But you have to decide you want to go alone, right?
That's true.
Or you want to bring your family, or you bring the extended family. So many things to decide, And this is only about a trip. Yeah, like you're just going to Bangkok, so you decide to go on your own, sure. But you might have
itinerary, what you want to do.
Correct. So there's it's just a simple trip, and you have to make so many decisions. Can you imagine? This is your healthcare, your life, how you want to live, how you want to be cared for. Now that's advanced care planning. That's like planning ahead for the future healthcare wishes. If you don't think about it and you don't tell anyone about it, then no one will know. Yeah. So that's advanced care planning. Can I go on a bit more about advanced care planning? Okay, can. All right. So what is it? So it's basically a voluntary discussion on your future care preferences. For example, how you want to be fed if one day you're unable to swallow. If you go into renal failure, do you want dialysis? Do you want invasive treatment, operations, chemotherapy? And this kind of information can be used by your loved ones and your healthcare team when you are too ill to make these decisions. Now, do you leave it to your family? A lot of old people say, yeah, just leave it to my son or my daughter. They will know what to do. Even my parents tell me that you know what to do. Okay, but or do you think that it's better to talk to them, tell them what you wish for ahead of time? Because Patrick, can I ask you, if you ask your family to buy you a kopi, right? Yeah. Will they order the correct kopi for you or not?
It sometimes get it wrong.
Get it wrong, right? So do you like kopi, kopi O, kopi C, kopi siu tai, kopi peng, kopi kosong? So many kopi, right? Which kopi are you going to get? Are you so sure that they're going to give you the correct one, right?
I got a different problem. They ask me for money first.
Exactly. So, it's related, So sometimes we don't even drink coffee, So I think it's important to actually let your family know what is important to you, what are these decisions, so that, one day when it's your healthcare and the decisions get harder and harder for your family to make, right? If they have no idea, it's going to be really, really hard for them to decide. Yeah. Okay. So, why do advanced care planning? As I said, if your family knows, then in a medical crisis, when you're not able to speak up for yourself, then the family knows what to do. They know that you do not want dialysis. They know that you do not want chemotherapy, whatever treatment it is, because otherwise they are going to feel very guilty for saying no. They're going to feel very stressed. And then the big brother and the little sister are going to have a fight, and there'll be a lot of conflict within the family. So by having this open discussion, a lot of times we can remove the conflict when a medical crisis occurs. Also, you can also avoid like inappropriate invasive treatment that you don't want, but your family doesn't know you don't want. So if you don't tell them, they might make you do it. So that's one of the usefulness of advanced care planning, letting a family know what is important for you. Now, the next thing that most people will ask is, who is advanced care planning for? Is it for old people, sick people, or is it for young people? So actually, advanced care planning is for everyone. But it's particularly important for people who have chronic diseases, who are starting to have a bit of memory issues or approaching end of life, because it's good to share with your family what is important for you at that point in time. Other things that people do ask me is, should I do it now? Should I leave it later? When should I do my ACP? Should I do it, when I'm sick in a hospital, then I'll do it. Now I'm still well, I'm still going to the shops, going marketing, going shopping, going Bangkok, So should I do my ACP now? Well, life is unpredictable and you never know when you need your ACP. And it's a good way to plan ahead with your family, because it's always too early until it's too late. So let me just share with you the steps to ACP facilitation. It's just 4 simple steps, not too complex at all. And the first step is actually understanding your illness. Let's say you have an illness. Let's say you're well, then that's great. Then you just reflect on what are your values, what's important to you. Is being independent important to you? Being able to feed yourself, walk around, do your thing, is that what is important for you? And then think about the values that's also associated with that. And then the third part is finding a spokesperson. So the spokesperson is very much like the donee. It's like the person who will speak up for you when you're sick, and then tell the doctor, hey, my dad said that he wants this and he wants that, and please don't make sure that you don't do any operations on him because he already told me he doesn't want that. So that's a spokesperson. A spokesperson has to be someone who will listen to you and do what you want, not what they want. Because a lot of times, other people, they will do what they want. So you got to find somebody who will speak up for you. And then lastly, once you've gone through all that, you document it all down, and a facilitator can upload it onto the National Electronic Records. So actually, if let's say you are admitted to a hospital, a public hospital, we can actually pull up the advanced care planning documents and see this discussion that you've had. So it's incredibly useful for emergency, for medical crisis. Okay, so for example, just a very quick example, a 40-year-old person shares with me that actually I'm still young. I want to see my children grow. I still have to bring them up. I've still got lots of things to do. So her advanced care plan, the reasoning behind is that being independent and making sure that her children grow up is very important. So she will want everything that if she becomes sick, do everything that you can to make sure that she can, recover. And she might share that, okay, if it's a point when I cannot recover and I'll become dependent, then that's a point when I do not want you to do any further research. It can be quite clear exactly what is important to you and what would be your goal. Versus an elderly gentleman who might share with you that, hey, I've had a really good life. I've got like 10 grandkids. I've enjoyed my life. Please don't do anything to me. I just want to enjoy my life. My main goal is not to have any suffering. So it's very different. As you get older, you have different preferences. So the great thing about advanced care planning is you can review it and change it as your life changes, as things happen. Sometimes you change it because you have a grandkid and you want to change from not too active to become more aggressive treatment, or as you get older, you feel, okay, I don't want to have too much aggressive treatment, and that's what you want to put in your advanced care plan. So it's really your choice what you want. Okay, just a couple more slides. There's a lot of misconceptions about advanced care planning. So sometimes, I bring up advanced care planning and the patient goes to me, oh, are you talking about insurance? Or are you talking about end of life? So one of the common things that people think about is that, oh, are you talking to me about death? I must be dying if you're talking to me about advanced care planning. But actually, it's an ongoing discussion. It may be about what you want and not about death per se. It discusses about your values and your beliefs and your wishes. Okay, and ACP is really not for the old and the sick. It can be for everyone because we all have wishes. We all have healthcare goals, no matter what age we are at. Okay. The next slide is sharing a few more misconceptions. So some people think that, advanced care planning is about stopping all life-sustaining treatments, but actually it's your healthcare preference. So it could be for active resuscitation, like I shared the earlier case, or it can be about limiting the number of treatment that you want because of a particular reason based on your goals. And when we talk about advanced care planning, it's not that the medical team has given up on you, but rather they want to hear your side, what is important to you. And then we can have aligned goals. All of us are working towards the same goal and not towards the opposite side. So those are the advantages of advanced care planning. Really, really useful tool to use to put down your healthcare goals, what's important to you, share that with your doctor and share that with your family. And it will really help when the medical crisis occurs. Shall I?
Okay, we have some questions coming in. Maybe I'll just jump in with my own question first. Actually, one of the thoughts that ran through my head is actually we don't really know what we want to do sometimes until we actually experience it. And you did mention that advanced care planning is an ongoing process. So does that mean that actually if I've come up with a plan or certain sort of guidelines for my family to follow, can I just deviate from it when the situation actually happens to me?
Usually the advanced care plan is only activated when you can no longer speak for yourself. So let's say you are sick, but you're not that sick that you can't share with the doctor. We will still speak to the person rather than use a document. The document only becomes activated and it's not a legal document. It's just a document to help the family as well as the doctor in terms of the guidance of treatment. So if you are able to speak, we will listen to you. If you want to change your plans, we will definitely listen to you. We do not follow a piece of paper. The paper becomes useful only as a guide when you are not able to speak for yourself.
Okay, and then we have this question. Who can help you with advanced care planning? Are there firms providing such services?
Okay, so if you go to my legacy site, I think we're going to give you a QR code at the end of this talk. It's got information on where you can get advanced care planning done, as well as lasting power of attorney. But I work in Tock Seng Hospital, and we have a very active advanced care planning team there. So if you go to the Tock Seng website, you can also get the contact number. We can share that with you later.
So I think this question leads nicely into the next segment where we compare what we've discussed in the webinar so far. We have a question that has the most votes tonight. What can go wrong when someone only has an LPA but no ACP?
Okay, good question. Thanks for asking that. So LPA, right? It tells you, okay, this son or daughter is going to be your donee. Okay, but did you actually tell your daughter what you wanted? What are your wishes? To what extent you want a certain thing? Although LPA covers the property and assets, it also covers healthcare decisions and where you live, how you want to live. So a lot of times we appoint someone, right? But we never tell that person what we actually want. And advanced care planning is a great time to actually sit down and talk. And honestly speaking, right, it's really hard to bring out advanced care planning to your parents. I tried that and they just like blocked me. So I had to try many, many times before they even talk to me. So it's really hard to bring it up. So when we say advanced care planning and say, hey, come and do it, right? We have a facilitator to help guide the conversation. Sometimes it's hard for us to bring it up to our loved ones. It's sometimes a very sensitive topic. So by having a place where you can sit down with your loved one and a facilitator who will guide you in the conversation, it really helps to open up a lot of doors. You hear things that you'll never hear from your parents before, I had a patient who, every time I see her for high blood pressure, she will just say hi, then we'll just check the blood pressure. But then when I did the advanced care plan, oh my goodness, I learned so much about her and her family as well. She shared with me that she grew up in the farm. What was important to her was being able to do things. She loved gardening, and she was sad that she was getting old. She couldn't do gardening anymore. She was trying to share with myself and her family that she didn't want dialysis. And it was through the conversation that the family finally understood, exactly why she didn't want dialysis. It was like, you could do dialysis, what's wrong? Why don't you just have it, But by having that conversation together, they could hear her voice. And that's what we want. We want to hear the patient's voice.
Actually, Dr. Adeline, you would be best placed to answer this question. So can your wishes inside the ACP be overridden by a doctor's medical opinion? For example, if somebody wishes or states that he wishes to be resuscitated, and the doctor's view is that there's no benefit to resuscitation, and so would resuscitation be carried out in the case, for example, of cardiac arrest?
Thanks for that question. That's a very, very tough question. I would say that the advanced care planning is a guide to the medical team. The final decision is still the medical decision. So I think usually in this kind of situation, the doctors will explain to you the reason why they would be advising not for resuscitation rather than just say, this is my decision. Most of the time, we try to address the questions and things that arise in this kind of situation.
Okay, and I think now we can talk about a little bit about how the different instruments or documents relate to each other. So we earlier talked about DONIs in the context of LPAs, and in the context of advanced care planning, you also have to appoint a spokesperson. So are they usually different people? And what if these different people disagree with each other?
Good question. I've not seen it before, but I can imagine it happening. I think everybody has their views, and within a family, even within the children themselves, I've seen different opinions from different children. So I think that honestly, if you choose the donee, it should also be the spokesperson if possible. The conditions to choose the spokesperson, right, is that this person must really speak up for you and not their own opinion. Whereas a donee can just follow through if you have given specific instructions. Whereas, in a healthcare spokesperson, in a medical crisis, this person cannot panic. They have to stay calm. So you have to choose a person who will stay calm in a medical crisis and remember what you spoke to them about and speak up for you. So I think those are the conditions. Ideally, you'll find one person who can do both. But if you really, really cannot find that, then hopefully the two people that you've chosen are friends. But I think even friends can start fighting over something like that. So I think perhaps open conversation with both of them might be a good idea.
And how do we go about doing this advanced care planning? Must it be endorsed by a doctor, or can we do it by ourselves?
It's usually facilitated by a trained facilitator. There are facilitators in all the public hospitals, in the clinics as well, and some of the private GPs as well. There on the My Legacy app, there's a list of places that you can get your ACPs. The facilitator needs to just endorse it. There are two types of ACP, which I didn't go into detail earlier. The general ACP for well people, and the preferred plan of care for the people who are not who are approaching the end of life. So for the preferred plan of care, we usually will get a doctor to endorse it as well, and it will usually be the doctor who is your primary physician. So if it's like the patient that I told you about, I will endorse it. Actually, I was a facilitator and her physician as well, so it can be easily endorsed. But if let's say another facilitator does it, then for a preferred plan of care, we will usually get a doctor to endorse it as well.
Okay, maybe so moving on to the next slide, we have a table setting out the different or the differences between the things that we have discussed today, advanced care planning as well as LPA. And we also have the Advanced Medical Directive. So maybe Dr. Adeline, you want to share a bit more about that?
Okay, so many a times advanced care planning and advanced medical directive, they sound quite similar and they often get confused. So I've gone through advanced care planning and I just wanted to highlight some of the differences between the two. So advanced care planning is a series of conversation. It's not a legal document. It kicks in when you lose your mental capacity, and it helps guide the doctors and your loved one as well as to what kind of treatment and management you would like. Whereas for Advanced Medical Directive, it is a legal document. It came into effect in 1996, and it is under the Advanced Medical Directive Act. So you actually have to fill up a form, get 2 witnesses, and submit it to the registrar of the Advanced Medical Directive at MOH. It also kicks in when you lose your mental capacity, but it has 2 more conditions that need to be fulfilled before your advanced medical directive is activated. So first, you have to lose your mental capacity. You have to also be terminally ill. That means you are very close to death. And the third one is actually death is imminent. If you don't fulfill these 3 criteria, then you cannot activate your advanced medical directive. So it's a very particular situation. And what does it do? It obliges the doctors to not continue any extraordinary life-sustaining treatment, for example, ventilation. So advanced medical directive, very specific timing that it kicks in and for a very particular condition, like the doctor, it has to do with stopping life-sustaining treatment. Whereas advanced care planning is about almost everything. It's like an umbrella, it covers everything, you know. Yeah. So that's the differences between the two. Lasting power of attorney and will, I think, has been covered by Josephus.
So can you explain how these different documents come into play at the different stages of our lives?
So if you look at the table that I showed, when you have mental capacity and you're well, besides the LPA and the will, which Josephus told you about, please also do your advanced care planning. You can also do your CPF nomination. So you can do all that when you have mental capacity. The minute you lose mental capacity, you cannot do any of these documents anymore. Okay. And when does the ACP and the AMD and the LPA kick in? It's when you are when you have lost mental capacity, you cannot decide anymore. Advanced care planning, it can be activated and it will be useful throughout. Whereas the advanced medical directive just is activated just before death. So that's the main differences between these different life planning documents. Hope that helps.
Yeah, so we have one question from the audience. What happens when circumstances change after someone has made an ACP, but circumstances are such that it's impractical or unrealistic to implement the things in the ACP, but the person does not have an LPA? Who then makes the decisions?
I think if the person still has mental capacity, is that what you mean? If the person still has mental capacity, you can always change your advanced care planning.
I think the person in this case has
lost mental capacity. Yeah. So sorry, the question again. So if you cannot do some of the things that's requested, is it? That is true. It has happened. So sometimes an elderly, elderly, sometimes they feel very strongly about going home to pass on at home. And sometimes that is just not possible because of the condition, the illness that they have. So some illnesses can be very symptomatic and they may need to be in a hospice or the family is unable to look after them. So sometimes when we do advanced care plan, some of these things are discussed. We do say that sometimes we may not be able to do this at the end, but I think you can try your best. I think the main thing is to get the idea of what is the most important for the patient, and you try your best to fulfill those things. I think some things, if it cannot be fulfilled, I think the best, if you force a person to go home when the family is not ready to look after, I don't think that would be in the best interest of the family or the patient. So I think in the end, the final decision is whatever is best, the best decision.
Okay, now we have talked about very many different things, and I think it's time to try and organize our thoughts. So Patrick, maybe you can share a little bit more about this. What what kind of steps should people should they start to take when they start thinking about all their life affairs, including LPA, all this?
But really, I would like to thank Josephus and Dr. Adeline for a very, very good mix of the black letter law as well as the more medical perspective for today's session. I think we have always described things in the hard letter law, but you realize that in this topic on wills, estate planning, as well as LPA, that a lot will depend on, is beyond just the black letter law. Very important to as we embark on this journey, to listen to the wishes of those who are the elderly, or for you to communicate your wishes. I think very, very important. And I sort of like extricated a 3-piece meal from them. What I call LAW law. So maybe in anything you do, remember to have your lasting power of attorney, your ACP as well as your will. So remember that. So remember that you better get a 3-piece meal done. Yeah. In fact, as I was listening to Dr. Adeline talk about the ACP, in fact, I actually went through the SG Legacy website and the resource. In case you're not aware, there's actually a live SG app. I think government is trying to push this app across, and there are many e-services available. And trust me, the app is extremely useful, not just for the e-services and government services, but also for ACP as well. If you navigate the app, or you can go to the website. I think the app is easier. Download the app, Live SG, and then you can actually go through all the resources. Then they have a direct link. You just tap, and it goes there. And for those of you who are helping your family members and parents, because you need SingPass to get into Live SG, so therefore you probably need to help them navigate the space. But otherwise, the website does equally well. But back to this topic, I think very, very important. In my work with union leaders and unions, and many thanks to many of you who are tuning in and who have signed up for today's session. In fact, today's session is co-organized between Pro Bono SG and National Trades Union Congress, because this issue of wills, lasting power of attorney, and advanced care planning has been cropping up time and again at our legal clinics. We have this 3-piece meal as well. What we call the legal primers, which is tonight's session. A monthly legal clinic. In case you want to find out more, get a consultation, get a free consultation, you can actually sign up for our legal clinics. It's a monthly legal clinic, which we co-organize, as well as we have pocket series of workplace-related issues, which you can have reference to. All these are downloadable and available online, free of charge. But more importantly, this issue on wills, intestacy, as well as lasting power attorney, as well as advanced care planning, has been cropping up in the heartlands, in the community, even in the workplaces as well. It's something very, very important, because we want to hear the wishes, or we want to let our family members, our loved ones know our wishes. Because in my work in the community and with workers, many a times, for example, those who pass on because of workplace injury, they did not have a will. And it adds to the complexity and the pain of family members. I've attended numerous funeral wakes. Sometimes I have to go there and advise them and ask more probing questions. I feel for them. The wife, the sole breadwinner of the family is gone, and then the wife is now left alone, don't know what to do next. So I strongly feel, the 3-piece meal of having a lasting power attorney, ACP, as well as a will, is very, very important, and it reduces all the heartaches of the people that survive you. So that's one very, very important. And second, I would like to also mention that the SG Legacy, the Live SG and Advanced Care Planning, one of the useful things is makes you think. If you go through the bullet points, makes you think through what are the things that you want to outline your wishes for your loved ones after you pass on, or as well as if you are on a deathbed. Why is this important? Because I've also, in the course of attending some of the funeral wakes of my residents, oftentimes hear of family quarrels. You'll be surprised. Many family quarrels arise through funerals. Things like, what kind of funeral do we do? Is it a Christian funeral, a Taoist funeral? What kind of photo do I put on the tablet? And you'd be surprised. Things like this actually hurt feelings and affect relationships. How you handle the body, the ashes, whether you cremate, whether you bury, or where do you cast the ashes. You'll be surprised all these things actually lead to a lot of family quarrels, and therefore, I've encountered many of them, and therefore advise everyone who's tuning in to go through this. Well, it's a process. Sounds long and tedious, but I think it's a useful process, and there are various guides for you to write down and to dictate some of these wishes that you want, and to make life easier for everyone that outlives you. I think that's very, very important. And Josephus touched on it, the LPA. I can't emphasize more the importance, because I have residents who come and see me, and then they wanted to help their aged mother who has lost her mental capacity, and but she has quite a significant amount of money in the bank. But the bank won't release the money for the immediate family member, to draw on to pay for medical charges, ICU stay, and stuff like that. So that's where the frustrations come in, and then there'll be a process under the Mental Capacity Act, and like what Josephus mentioned, not just cost, but it's a time. It's time of the essence when people are ill. So that's the frustrating bit of it. And they have come to see me, and unfortunately, I said, do you have an LPA? No, and therefore you have to go through the deputyship procedure, and that leads to more heartaches, and you have to find alternatives. I mean, for financial support, and and the frustrations of the whole process. So these are real life examples. I'm not joking. I mean, I've seen it personally in this many years. When it comes to not having a will, when it comes to mental capacity, and as well as not having a lasting power of attorney, and not proper advanced care planning, especially during your when you pass on, what are the things that you want family members who survive you to do for you and to not do. Yeah, so there are instances. I mean, my friends in the undertaking industry tell me they also sometimes they feel for the family members, because they see a lot of all these unnecessary quarrels resulting because of that. And finally, just one additional point, which that's a supplement what Josephus mentioned earlier. Well, the good news is the lasting power attorney Form 1 registration charges for Singaporeans are waived by OPG till 31st March 2026. So, but there's still a separate charge. So that's only for the registration application fees. Yeah.
Okay, I believe we have some time to try and answer some of the questions that are from our participants. So there are some questions relating to the registration of wills, and now any of you can feel free to answer or chime in. Is a will automatically registered or logged with the Singapore Academy of Law the moment it's prepared by a law firm? And related to this is, what if my will is not registered and the original copy is missing? What do I do?
I'll answer this question. So already I mentioned just now, this is a register, okay? A will registry under the Singapore Academy of Law. So if you do register your information of your will there, right? It like I said, it's not a storage. So it doesn't store a copy of your will there. Basically, you're just giving information saying that, okay, I did this will on this date with this law firm, and that's it. Okay, so that is the first part of the question. And the thing is that, what if you lost your will, right? Then how? Then no will lah. Or if you still alive, then quickly go and do another one lah. That's really the long and short of it. So we always tell our clients, like if you do the will with us, right? We give you the original, okay? The moment you walked out from my office, and you discard it, you lost it or whatever, right? That's it, Okay, so I mean, so that's the reason why some companies out there, or even law firms, right? They actually provide custody service. So they will say that, hey, just in case if you do any of this, right, you lost it, you misplaced it, whatever it is, right? Maybe you want to store it, all right, in a fire safety facility, in a waterproof facility, for safekeeping lah. So I think even the banks, they offer such custody services as well. So that's something you might want to look into.
Yeah, but more importantly is your family members, or the executor of a beneficiary should know where you kept
exactly.
your will.
Very good point. Yes.
Yeah,
yes.
because sometimes some of us prepare a nice will and then we put it in a bookshelf, and nowadays many people have short-term memory loss, and then they forgot where they put it.
Yeah.
Lo and behold, touch wood, and nothing happens. Something happens, nobody know where the will is.
Correct.
Yeah.
Correct.
Then what happens if the witnesses passes away? So we have a question. Is it a legal requirement that the two witnesses must be alive or contactable for the will to be enforceable?
No. No. So, okay. The whole idea of having two independent witnesses, right, to a will, right, as part of the legal requirement, the legal validity of a will is this. If there are no challenges, right, no dispute as to the validity of the will, then I don't think there's an issue as to whether the two, or at least two independent witnesses, they must be alive or dead. I think only when there's a challenge, especially in the courts, you are saying that, oh no, I challenge, I dispute the contents of the will. I disagree with the distribution. And then if somewhat that arises, then that is where I think, of course, it matters whether the two or the one of the two witnesses in that will, right, they are alive or dead, because they might be summoned to court to testify. All right. But long and short of it, if you see, if you ask me what we are seeing on the ground is this: many of the customers, they did their wills with us, then some of them, they passed away, they came back to us, and we do the application to the court for the grant of probate, right? Yeah, no issue at all. Because some of them, we know for a fact the witnesses, they have already passed on as well. So yeah, actually there's no dispute, no issue. Yeah.
Then what about the deceased debts? So what happens if the deceased debts are more than his or her assets? Is the beneficiary actually liable to pay off the deceased debts?
Very good question. You know, in Chinese, they always say 父债子还, right? Not true. Okay, so the thing is that if, let's say, this person, I decided to will everything, to let's say my children. But upon his death, you find that actually he became a bankrupt. All right. So then, of course, you whatever balance left in your estate, you have to pay off the debts. Okay, that's according to the legal stipulation. And after you pay off all these things, you realize that actually inside is negative. Then too bad, That means whatever that is being written in the will, as in to be given to the children, to them as beneficiaries, end up you get nothing. So the estate becomes insolvent. Correct. But it doesn't follow the case whereby, just because they're outstanding debts, even after using the estate to pay off, still got balance, then how? That means the children or whoever is named as a beneficiary must carry on the debt. No, no need. Okay, the estate just becomes insolvent. But that also means that if you are the beneficiary, you get nothing.
I just wanted to chime in and help CPF board a bit, to remind everyone that the only thing that is outside the purview of the Wills and Intestacy Succession Act is actually the CPF nomination.
Yes. So
no matter what, make sure you make the right nomination and the contemporaneous one, because that whatever you made, nowadays these days is quite efficient. You can use through the CPF app. You can see when you last made a nomination. Then you can go into the details if you're SingPass mobile. And but I just want to emphasize this again, because I have cases where unfortunately, the CPF nomination was made to the ex-wife, for example, ex-spouse. And then there may be quarrels later on because, unfortunately, the new family does not get what the CPF nominations as nominated, as previously, maybe a decade ago. So just watch that. Yeah.
Very good point. So the thing is that CPF nomination, okay, just to reiterate, cannot be covered in a will. It's by nomination. Just use the app, go online. You can do it in less than half an hour. Okay, so please go and nominate your CPF monies.
Okay, now we have a question relating to ACP. So for example, when an accident happens or a patient suffers a stroke and an ambulance is called for, do they actually check for the existence of an ACP, or at what point will the medical team involved check whether the person has done an ACP?
Thank you so much for that question. That's an excellent question. And it's an area that we are working on at the moment. So because the advanced care planning document is not a legal document, so the ambulance officers are not allowed to look at it as of now. I think that for patients who do not want to be resuscitated, or they are under hospice or other palliative care, then the doctors who are looking after these patients will know how to advise the family what to do if the person becomes very ill. Rather than call the ambulance, you can actually call the doctor to do a home visit. But let's say that the patient does, the ambulance is called and the person gets sent to the hospital. Then if it's if you have a copy, so usually we give you a hard copy of the advanced care plan. If you have a copy, then great, bring it with you to the hospital. But a lot of times it's copy will get lost. So the emergency department doctors will usually look, if it's a hospital that you usually attend, this is a regular hospital, it will be in the notes, in the electronic records or in the national electronic records. So this NEHR is, all doctors can access this. So you can actually see the advanced care plan if you do turn up at the hospital. Yeah, so that's a good thing that you can lodge it online. It's on the IT system, and this can be, as long as you have access to the national electronic records, you can actually see the advanced care plan.
So I think some of our participants also have some questions about the interactions between ACP and LPA, and as well as DONIs. We have two related questions. The first is, which one has more power or takes precedence when one loses mental capacity? Is it the ACP or the LPA? And related to this is, what happens if, for example, your donee intends to put you on life support and this is contrary to your ACP?
Oh, fantastic question. Thank you very much. So for LPA, the donee cannot decide on life-sustaining treatment. So the donee cannot override the medical team. For the first part of the question, who is more important, the donee or the spokesperson? I think they should work together for your best interest. That's why you chose that person to be your donee. I think if one, I think they do cover different areas of care for the person. And so they may not necessarily overlap the areas of coverage. When it comes to medical decisions, then the healthcare spokesperson will be the one that we are looking to for guidance. We can also look at the advanced care plan as well. For the donee, I think the personal welfare and that becomes the decisions that need to be made. Hopefully they do have an idea what the donor would have wanted. So I think ultimately, right, when you are chosen to be the donee, you're chosen to be the spokesperson, do act in the best interest of the person who has nominated you. I think that's the most important thing. That's the most human thing that you can do.
To add on to Dr. Adeline, just remember rule number 1, don't find anybody from Kopitiam Hawker Center, whether it's as a donee, as an executor, or as a spokesperson, okay? Find somebody you can trust to act in your best interest.
Yeah, I learned from both of you. Must have one BFF.
BFF, okay? Must have one
No,
BFF.
it's true, you know, right? Because there may be a scenario, for example, you're a husband and wife, you have 3 young children, and you make, for convenience, usually make your spouse executor. What happens in a travel accident?
Yeah,
both husband and wife passes on.
Yes.
There's no executor. So to have a BFF, I realize is very, very important.
Yes.
To act as your executor.
That's correct.
So I think someone had a question. Are there cases where the executor did not distribute their assets to the beneficiaries? I think if we broaden this question, are there cases where donees or spokespersons don't act as they are supposed to, and what are the safeguards for such situations?
Okay, I think straightforward lah, because the thing is that you see, don't take this lightly, yeah. So if you are ever chosen as somebody else's executor, appointed as a donee or as a spokesperson, no, I kid you not, take this very seriously. There's a legal obligation. So for example, in the context of executor and the donee, right, if you are so appointed and end up, right, you don't carry out, for example, you apply for the grant of probate, then you obtain the assets, right, after paying off the debts, right. For example, if you're not the intended beneficiary, you're supposed to give it to the children, but you use it for yourself. Hey, this is a chargeable criminal offense. You'll be taken to court. Okay, and chances are you'll go to jail for it. And same thing as what I mentioned earlier, we have seen the very, very sensational case of the tour guide, right? So if you're the appointed donee, you must act in the best interest of the donor. So once they lose their mental capacity, you are given the powers, to take charge of their personal welfare, their property and finance. You are given the power to draw money, from their banks, And we have seen cases like that, you draw the money not for their welfare, but you actually use it to gamble, to buy luxury goods. You'll be taken to task. You will be taken to task. It becomes a criminal matter. Okay.
Okay. And now, questions about LPA. So what happens if the donee is also sick? Do I need to add another name, and how do I do so? Or do I need to redo the whole LPA? And if I want to change the donee, how do I do so?
Okay, long and short of it, you can get more information from OPG's website. But I can tell you right now is that if you really want to change, for example, if you only appointed one donee and for whatever reasons, maybe the donee is away, working overseas or unwell or not easily available, like uncontactable, right? You can always do a revocation and reappoint another donee. Okay, I think you just need to pay a small little admin fee. Okay, so read out the details on OPG's website. Alternatively, like I mentioned earlier, you can appoint donee 1, donee 2, and a replacement donee, right? For whatever reasons, like for example, if donee 1 or donee 2, whichever, if let's say they can't execute their duty, and that's where the replacement donee can actually step up. Long and short of it. Okay, for more details, just go to the OPG website. It's all listed there.
The interesting question. If none of the family members are beneficiaries, do they still have a legal right to contest a will that's being made?
I tell you, people can contest anything with or without basis, okay? Because there are a lot of xiao lang out there, you know what I mean, right? So the thing is that, well, a lot of people ask me this question. It's like, hey, can we dispute this? Even with a will, you know, even with exclusion clause, a specific exclusion, I don't want this person to be part of my will, can receive nothing. Even that, people challenge. Then we were like, huh? Hey, but the person who passed away said, died, 指名道姓, you know, with your name, IC number, say you're excluded from this will. You challenge what? No, I think maybe he's a bit groggy, you know. Yeah, I think he loves me, you know, but it's just that I think maybe some misunderstanding. So this can't be true. Still go and contest, fight it out in court, can. But you know, I know lah. Ultimately, when it comes to court case, right, in Singapore, like they say, it's not what you believe, it's what you can prove. It's about evidence. Always remember, law is about evidence. Right, but you can contest all you want now, of course. But when you have a will, a written instrument that reflected the last wishes of the testator or the testatrix, I think it's very clear. It's very good evidence to the courts. If the matter ever goes into a dispute, those will be the last wishes. Yeah.
Okay, Dr. Adeline, I think I have some questions for you. Can a medical officer make a decision to stop life support without reference to an ACP, assuming that it exists?
By law, if they are not aware of the ACP, then yes, I would say. But I spend a lot of my time increasing awareness in the public as well as in the hospital, making sure that the doctors know where to look to access this very important document. But in the event that they do not know that there is a document, then they may not be able to take it into consideration. A lot of times we do take it into consideration when making decisions together with the family. We do not just read the document and then decide. A lot of times it is in discussion with the next of kin, the loved ones as well.
Okay. I think this is also an interesting subtopic. I think we talked about trust services earlier. We have a question that says, do we have any government agencies besides SNTC that provide trust services for special needs adults?
Well, yeah, I mean, if you ask me, again, this is my personal opinion. I think really if you have a special needs kid, we will always advise clients, I think, go to SNTC. All right. I think they were created for this purpose, really. So they are really an organization, a company that's dedicated to providing services in cases like that for special needs kids. So really, SNTC is really the one that we will advise you to go to. You know, if I have to give my personal recommendation, you know, no other place, SNTC is the one.
Okay, we have some questions. I think, do all assets go into a will? What about assets that you have prior nominations for? I think this was already answered earlier. Dr. Adeline, are there any issues if your spouse is a physician and the spouse is a witness for the medical part of the ACP?
Usually, unless your spouse is also an ACP facilitator, we don't usually recommend your spouse to be the person doing the ACP for you. Sometimes it's the discussion that's important, and you do need that an independent person, a facilitator, to encourage the conversation. you know, if your spouse is the facilitator, you know, he might be using that to try and not discuss a lot of things. So to be open about it, I would advise to get an independent person to do the discussion for the two of you. I'm also tempted to do it myself for my own husband, but I don't think that's the right way to do it.
Okay, thank you,
Thanks.
Dr. Adeline. Now, what about donee's duties? Can I ask a donee to take care of for example, my ill grandmother, including providing financial support? Is that something that can be done?
Oh, this is a question about LPA, is it?
Yes.
It really depends on the powers that the donee has been given. Whether, like I said earlier, because you know, generally speaking, when we talk about LPA, you are talking about really two sets of powers: personal welfare and property and finance. So it really depends on the donor, right? When they have their mental capacity and when they actually draft the LPA, what sort of powers are they giving you? And also whether is it jointly and severally. All right. So I really can't answer this question with precision, but the long and short of it, it really depends on what the donor wanted, you know, when they did the LPA. All these are listed it's like a standard form, you know, they would have to sign it, you know, it will have to be certified by a so-called certificate issuer, which can, under the law, can either be a doctor, accredited doctor, a psychiatrist, or a lawyer. Okay, so again, coming back, please, certificate issuer can be only done by one of these three, okay? Accredited doctor, medical practitioner, a psychiatrist, and a lawyer. Don't find anybody at a kopitiam hawker center to do it. Please, I cannot. Okay.
Okay. I think before we end our webinar today, maybe I'd like to invite each of our speakers to leave us with one key takeaway for today's webinar.
Maybe I'll start first. Well, back to the 3 points, the 3-piece meal. Just make sure you do your LPA, you know, your ACP as well as your will, because we have seen many cases where well, a lot of not just cumbersome and onerous, but also time and energies, as well as resources and money is wasted. So please, I mean, after you attend tonight's session, I hope all of you will take all these three things, or this 3-piece meal very seriously, and really embark on it.
Okay, I just leave you with 2 statements. One is live for today, but plan for tomorrow. It's always too early until it's too late. So do your ACP as soon as possible.
Okay, for me, really, I'll just throw this question, you know, what Singaporeans like? All Singaporeans like 3 things, good, cheap, or free, okay? So the things that we talk about tonight, right? Wills, LPA, ACP, AMD, these are good things, okay? So please, good things must do. Second, affordable. Compared to the past, right? They are really not expensive as what people would like to think, okay? In fact, I think even for wills, right? I understand that there are some like free online will generator, you know, or even I think recently in the news, initiatives have been launched by the government, you know, to encourage especially the elderly to draft up their LPA for free, you know, done up by pro bono lawyers. All right, so affordable and free. So what is the free thing? Apart from the LPA, the LPA initiative, which I just mentioned, I think Patrick mentioned it, because for LPA, there's an application fee, but I think recently government announced that they're going to waive it all the way until 2026. So remember, good, affordable, and free. Then why not? Just do it straight away.
Okay, thank you very much, panelists, for joining us today and for your invaluable insights. To our participants, we hope you found our discussion useful. If you're facing any issues and you're an NTUC member and keen to register for a legal clinic, you may write to lawworks@ntuc.org.sg. But if you're a non-NTUC member, do consider registering, or you can approach Pro Bono SG at help@probono.sg. Now, at the end of this webinar, a survey form will pop up on your screen for your completion. We appreciate your comments and feedback. We'll use them to improve future webinars. And with that, on behalf of Pro Bono SG and NTUC, we would like to thank all of you for joining us tonight. Have a good week ahead. Thank you, everyone.
Thank you.
Thank you.